Everybody, I go by the appellation of Melchizedek Ban Shal Yahuwah Elohim, or you can just simply call me Melchizedek Israel. I come from one of the 12 tribes of the holy nation of Israel, the set-apart nation of Israel. Prevail with Yah, Hallelujah, Hua, our almighty power. Yes, we are children of the Most High Light, the Most High Knowledge, the Most High Wisdom, the Most High Discernment, and the Most High Intellect. Understand or overstand. In today's video, we're going to go into part 2 of the updated version of HJR 192 entitled 31, Discharging Debt and Monetizing Debt. Hope you guys have watched part 1 before you proceed on to this one. Before we do begin, I want to let you know, since it's evening, this time is actually wrong, it's actually 8:40, but we're in the 29th day of the 5th month called Ab. We're in the 5th portal, the 5th gate, and we're in the north right now. The sun is pretty much heading towards the north. We're heading northwest, and we're in midsummer, the second semester of summer, and we are in the second day of the week, which you so call Friday evening. The second evening of the week is Friday evening. The second day of the week is actually Saturday daytime. So I hope you guys had found part 1 of this video very useful. According to the Julian season pagan time, it's actually August 14, 2015. So before we begin, this is my channel right here. It's called Archangel Macintosh. I don't have much activity going on there because most people, I guess, don't contact me, or they don't know about me, or I don't know what's being said about me. But most people don't like me, and it's okay. I didn't come to Earth to be liked or make friends anyway. I came here to help, and I wanted to show you guys because I have now put some of my documents or videos on private. So if you do want access to them, like this right here is part 2 and part 1 of the UCC1 breakdown and general rules of application. I'm going to be going through all of the UCC codes and break them all down, but I will not make it public. And if I do, praise the Most High. And if I don't, may the Most High retain His glory. So things like this, like the breakdown of UCC, going into UCC1, Article 1, and breaking it down, becoming a sovereign creditor and how to use escrow accounts and things like that, I've turned all of them private. Accounting principles, the Federal Accounting, Standard Board, and the Generally Accepted Accounting Principles, the Generally Accepted Auditing Standards, the Federal Accounting Standard Advisory Board, and etc. All this have to do with accounting principles that govern bookkeeping. So all this, I'm putting it in private. I do provide services like becoming a secured party creditor. That involves a commercial security agreement, copyright and trademark affidavit, power of attorney affidavit, hold harmless indemnity bond, as well as a hold harmless agreement, as well as a notice of understanding, claim of right, and a couple of other documents for consideration of $90. And trust me, that's not a lot. And obviously, a lot of people are trying to secure their asset and have a bona fide prima facie claim, and that is what I'm helping people do, is actually, take hold of their own possession, learn how to use their own account, discharge debt, monetize debt, and do other things. So this video, I made it public because I think the public need to know this, and how you use it is up to you. I got laws on interest, usury, and unfair lending practices, laws that govern crimes, theft and robbery, racketeering, larceny, extortion, fraud, and etc. I have videos on clearing bad debt now, or bad credit now, and fixing up your credit. I have videos on the origins of debt, credit, loans, notes, and money. This is basic money mechanics, modern money mechanics. Also have a video on the actual bill, the Negotiable Instruments Act, the IOU notes, bills of exchange, check, and acceptances. I believe this may be UCC 3 or something like that, but it may not be. It might be the actual Negotiable Instruments Act. How to defend yourself in court, subpoenas, counterclaims, relief, and things like that. Part 1 for becoming a sovereign. I also go into videos like the Routing Number Act, which is the ABA Act. And what makes these videos so great and perfect is because of the commentary. And do remember that this is for educational, entertainment, and investigative purposes only. You see, I do not make money from these videos nor these commentaries. This is out of my own time as my form of consideration to the whole. So I have done enough, I've provided enough, and now it's time for me to be paid for my own services. I am worthy of my meat. It's not like I'm unworthy for the payment. I am worthy of it, and I deserve it. And out of all the people out there, I'm actually putting my life on the line and risking it for you people. You don't understand how much danger my life is in for sharing this stuff with you. So I had to start making it private because I think people is using me. I felt used, abused, people contacting me about dumb stuff, about why do you charge for this or that? Well, because I'm learning how to monetize debt. And now that I know how to secure myself, and I've been the secure creditor since 2013, and I've been studying before that. So now that I know that, and I took the priority, I pretty much taking care of the priorities, and took care of everything in sequence, was first, was second, was third, in decent order. Now I can begin talking about what I'm talking about now. So I am a person, or living, breathing, flesh and blood man that's actually being built to help many. So I got Regulation X, dealing with real estate and real property. 1099A, acquisition, acceptance for value, defusing the charge, and satisfy the ledger books. And these are all the videos on my page. I don't believe that you'll be able to actually see it because I have it in private. But if you contact me at God Lives in Our Heart at hotmail.com, I will be able to assist you or provide you with the video. And know that I do not have to release it to you if I don't, especially if there's no consideration. So once again, I'm willing to share it for free, but at the same time I'm not obligated to, and I'm not selling the videos or selling the information. I'm just asking for consideration for giving it to you. Other than that, you can go ahead and look up the info yourself. If you believe you can, and you can compile what you learn over time for yourself. So that's none of my business. No offense, but that's really not my business. I love you all, but I will not be used, abused, and mistreated, manipulated, and controlled by anything you say, period. No contract. So you can also reach me at Skype under the screen name Archangel Macintosh. You see, and unfortunately, I do not believe I'm an archangel or anything like that. When I was in the New Age stuff, when my eye was closed and I thought I was doing something, I believed in that. But I kind of just kept the same screen name and did not change it to Malakizadaki Israel. So the screen name on Skype is Archangel.Macintosh. Remember, I do not give legal advice. I do not give tax advice. I just share what I think I know, and I share what is evident and obvious. We're actually seeing what they said, and we're using it against them as a form of remedy. I see nothing wrong with that. I take no responsibility for what you choose to do with this information, which means you hold me harmless, and we agree. And if you don't agree, I suggest to just stop this video now, because I do not want to be responsible for anything that you choose to do based on the information you have. So do your own due diligent research, and this is not an exhaustion on the subject. So all due praise to Yahuwah Elohim. So before we begin, let's go right here and onto this real quick. We're going to learn a little bit now that we learned a lot about HJR 192 and 48 Stat 112 and the statutes at large, and we've learned about Title 31, dealing with banks, money, finance, currency, and all that, and discharging debt. We're gonna go into a little bit about the birth certificate, and we're gonna go a little bit deeper into this. As you can tell, on some birth certificates, it says American Bank Note. So this is a note. Your birth certificate is a note. It's like money, and it's called the American Bank Note Company. So let's go down. So structure of the birth certificate, of the actual note. Did the state pledge your body to a bank? Right. Some birth and marriage certificates are now warehouse receipts printed on bank note paper or on bond paper, legal paper, which may mark you and yours as chattel property of the banks that our government borrows from every day. So this is by David Deschesney. Forgive me if I'm not saying it right, David. But all credit belongs to him for this document. This is for entertainment and investigative purposes. So editor, Fort Fairfield Journal. Fort Fairfield Journal, May 11th, 2005. So people been trying to warn us for the longest. So a certificate is a paper establishing an ownership claim. Boom. That's in Barron's Dictionary of Banking Terms. So registration of births, debts, corporate status began in 1915 by the Bureau of Census. So the Bureau of Census, they probably deal with statistics and things like that, keeping inventory of the populace, with all states adopting the practice by 1933. So birth and marriage certificates are a form of securities called warehouse receipts. Boom. And that's why it can be monetized according to everything we learned previously, because their money, their notes, their currency, they go around. Boom. So the items included on a warehouse receipt as described at section 7-202 of the Uniform Commercial Code, the law which governs commercial paper and transactions. So which parallel a birth or marriage certificate are? The location of the warehouse where the goods are stored, residence. So where is the goods stored? In the United States Corporation. That's where it's been delivered, right? In that hospital, right? From a docker, right? So the location of the warehouse where the goods are stored, or the state that is stored in, the vital statistics. The date of issue of the receipt, which means the date of birth of the product or the object or the entity. The date of issue, the date of birth. The consecutive number of the receipt, probably certificate number, found on the back or on the front of the certificate, usually in red numbers. Some call it a QSIP number, tracking number, serial number. Most people call it a QSIP number. So a description of the goods, like the product, black, tall, 5 feet, 3 inches, like 9 inches in height, 5 inches wide, like them describing a kid, or a footprint, placenta, DNA, all that. A description of the goods or your baby, or of the packages containing them, like name, sex, date of birth, etc., because this is what's being pledged as collateral for benefits. And that is the benefit. You give up your kids to us and we'll give you everything you want. You can get yourself a job. You can go to one of our schools. You can go get one of our food stamps and stuff. And we'll even give you a cattle number, social security number, which will never allow you to know what it truly is. And once you do truly know what it is, we'll find a way to destroy you. So watch out. There could be adverse effects in saying these things places. That's why I say I'm risking my life bringing these truths to you. This is no joke. So the signature of the warehouse man, which will be the docker, the one receiving the shipment or the ship. So that's signed at the very bottom of the birth certificate, the state, the county, all that stuff. And they put a certificate, a great seal on it, like a deed of trust, a mortgage, a title, a claim of ownership. And you can transfer ownership by giving up that instrument or becoming a holder of it by accepting it for value. That makes you the controller and trustee of it, if not the executor, administrator, or just beneficiary. So the signature of the warehouse man, which may be made by his authorized agent, municipal clerk, or state registrar's signature, where they register you into their system as one of their pledged collateral. The body, the vessel, the ship, your automobile. So birth/marriage certificates, which are corporate certificates, proof and receipt of the creation of a business. Yeah, you had a business since zero. Fraud committed upon you since an infant. So birth/marriage certificates now appear to at least qualify as warehouse receipts under the Uniform Commercial Code. Black's Law Dictionary, 7th edition, defines warehouse receipt. A warehouse receipt, which is considered a document of title, may be a negotiable instrument, a currency, and is often used for financing with inventory as security, inventory, stock as security in a stock market. So your birth certificate is asset, it's inventory, it's a product. So is your mortgage note and your car title. The VIN number, birth certificate number, and loan number. All these numbers are accounts. Bookkeeping. Someone's claiming your asset. So since the United States Corps went bankrupt in 1933, all new money has to be borrowed into existence. All states started issuing serial numbered, certificated warehouse receipts. Just like the dollar, it's a warehouse receipt. It's a note. It's a receipt. And every receipt is redeemable. They're all like warehouse receipts. They're redeemable. And on the dollar, it has serial numbers. It has an actual routing number, a letter that, like on the back of the back of the social, and that letter connects to one of the 12 districts of the Federal Reserve Banks, pursuant to the Federal Reserve Act and the ABA Act. So all states started issuing serial numbered, or like QSIP numbers, certificated warehouse receipts for births and marriages in order to pledge us or the product as collateral. And matter of fact, a jailhouse is a warehouse, and a ticket is a receipt, and it's proof that they own a product. They're entitled to their claim. They have a lien on you. And marriages in order to pledge us as collateral against those loans, and municipal bonds, mutual bonds, taken out of our account, mutual bonds, mutual funds, with the Federal Reserve's banks. So the full faith and credit of the American people is said to be that which backed the nation's debt. Like we read in part 1, that all debt is for the United States. That means citizens too. That simply means the American people's ability to labor and pay back that debt. Your time, labor, and energy. Invoke your fee schedule. So in order to catalog its laborers, the government needed an efficient methodical system of tracking its property, to that end. So humans today, every single one, are looked upon merely as resources. Human resources, that is. Human monster resources. Governmental assignment of $1 value to the heads of citizens began on July 14th, 1862. So, assignment of $1 value was appointed over the citizens. They became walking, talking peso, money. When President Lincoln offered 6% interest-bearing bonds to states who freed their slaves on a per-head basis. So this practice of valuating humans, cattle, continues today with our current system of debt-based currency, promissory notes, promises, faith, illusion, mind, what you believe, belief. Current system of debit-based currency reliant upon a steady stream of fresh new cattle to back it, fresh new babies, fresh new children, and they get them right when they come out of the stomach. So additional birth certificate research. So federal children, federal babies, Children of the Providence by Joyce Rosen Wald. So in 1921, the Federal Shepard-Towner Maternity Act created the birth registration, or what we know as the birth certificate. Now you know where it came from. Take note. It was known as the Maternity Act. So it was known as the Maternity Act and was sold to the American people, hook, line, and sinker, as a bylaw that would reduce maternal and infant mortality, protect the health of mothers and infants, and for other purposes. One of those other purposes provided for the establishment of a federal bureau designed to cooperate with state agencies, state bureaus, or state subdivisions in the overseeing of its operations and expenditures. What it really did was create a federal birth registry, which exists today, creating federal children, federal babies, bastards. And no bastard shall enter heaven, Yah said. But not in this sense. He actually meant those who aren't Hebrew. So this government, under the doctrine of parens patriae, now legislates for American children as if they are owned by the federal government. So they legislate for American children as if they are owned by the federal government, a federal daddy, the provider. Through the public school enrollment process and continuing license requirements for most aspects of daily life, these children grow up to be adults indoctrinated into the process of asking for permission from Big Daddy government to do all those things necessary to carry out daily activities that exists in what is called a free country. All due praise to Abba Yahuwah. Hallelujah. So before 1921, the records of births and names of children were entered into family Bibles, family books, as were the records of marriages and deaths, and it was in the family book. These records were readily accepted by both the family and the law as official records. Now it's not. It's not enough now. They want more and more and more. So since 1921, the American people have been registering the births and names of their children with the government of the state in which they are born, the place, even though there is no federal law requiring it. The state tells you that registering your child's birth through the birth certificate serves as proof that he or she was born in the United States. That ain't what happened. This is the real United States, thereby making him or her a United States citizen. Truthfully, the straw man is a member of the United States or a citizen. So for the past several years, a social security number has been mandated by the federal government to be issued at birth. It happens so quick you don't even know what you just did. And they won't let you out the hospital, which is coercion and duress. That's against the laws. So in 1933, bankruptcy was declared by President Roosevelt. Remember this man right here? The governors of the then 48 states pledged the full faith and credit of their states, including the citizenry, as collateral for loans of credit from the Federal Reserve Bank or system. Stem is sin. To wit, like the birth certificates, the mark of the beast. To wit, full faith and credit clause of Constitution, United States, Article 4, Section 1, requires that foreign judgment be given such faith and credit as it had by law or usage of state of its origin. So that foreign statute, so to wit, full faith and credit clause of Constitution of the United States, Article 4, Section 1, requires that foreign judgment be given such faith and credit as it had by law or usage of state of its origin. That foreign statutes are to have force and effect, like that foreign statutes are to have force and effect, like the statutes of limitation, to which they are entitled in home state, like a child of the house, like a house nigga, yeah, children of the house, of the providence, federal babies they call it, children of the feds, bastards. So in that a judgment or record shall have the same faith, credit, conclusive effect, and obligatory force in other states as it has by law or usage in the state from whence taken. So Black's Law Dictionary, 4th edition, cites omitted. All praise be to the Most High. Remember, you can contact me at godlivesinourheart@hotmail.com. godlivesinourheart@hotmail.com. You can also reach me on Skype under the screen name Archangel Macintosh. And I do offer asset protection help for a consideration of $90. And I've explained what that includes. One is the security agreement, and it will lead to the Uniform Commercial Code lien, the Department of Commerce. And actually your birth certificate goes through all that too. So the state claims an interest, a lien, a title in every child within its jurisdiction. The state, via CPS, Child Protective Services, will, if it deems it necessary, nullify your parental privileges and rights and power, and appoint a guardian, a trustee, like you, over your children. The subject of every birth certificate is a child or product. The child is a valuable asset. That's why it's been pledged. It's labor, time, and energy. Like a hamster on a wheel. The more it keeps the wheel spinning, the light bulbs stay on. Once the hamster start running on the wheel, the game is over. Which, if properly trained, can contribute valuable assets provided by its labor for many years. So they train you and reprogram you through college, through high school. 12 years you go to school and you don't know anything by now? 12 years in school you don't even know math well? 12 years in school you still don't have the best job on this planet? 12 years. If I was studying this stuff for 12 years, I would have been way farther than I've ever been through school. School actually keeps you stupid. You see, and what they tell you to do is what you must do to get an A. You see, and if you don't do it, if you don't comply with Satan, you get an F. And what does your parent do when you come home with an F? They get mad at you too. They make you feel dumb. They make you feel like you're nothing. So what do? You go back to school and you be an obedient little slave, and now you come back home with A's and your parents happy. So they're using your dumb parents to keep you stupid. You see? So it is presumed by those who have researched this issue that the child itself is the asset of the trust, established by the birth certificate, which is the statutory trust. And the social security number is the numbering or registration of the trust, the cattle number to the child, to the trust, to the product. So allowing for the assets of the trust to be tracked. If this information is true, your child is now owned by the state. Each one of us, including our children, are considered assets of the bankrupt United States Corporation, Intercorporation. We are now designated by this government as human resources. With like a cell, you put someone in a cell like a battery to charge, refuse. This all have to do with energy, which go in and out of form. With the new crop born every year. So in 1923, a suit was brought against federal officials charged with the administration of the Maternity Act. I want to probably check out that court case. Who were citizens of another state, to enjoin them from enforcing it, wherein the plaintiff averred that the act was unconstitutional, and that its purpose was to induce the states to yield sovereign rights, reserved by them through the federal Constitution's 10th Amendment, and not granted to the federal government. And that the burden of the appropriations falls unequally upon the several states. So held that as the statute does not require the plaintiff to do or yield anything, and as no burden is imposed by it other than that of taxation, which falls not on the state but on her inhabitants, who are within the federal as well as the state taxing power. The complaint resolves down to the naked contention that Congress has usurped reserved powers of the states. Congress has usurped reserved powers of the states by the mere enactment of the statute, like Statute at Large and Administrative Procedures Title 5. So though nothing has been or is to be done under it without their consent, Commonwealth of Massachusetts vs. Mellon, Secretary of the Treasury et al. Frottingham vs. Mellon, Secretary of the Treasury et al. So Mr. Alexander Lincoln, Assistant Attorney General, argued for the Commonwealth of Massachusetts, to wit, this is what he said. 1. The act is unconstitutional. It purports to vest in agencies of the federal government powers which are almost wholly undefined. In matters relating, which mean wholly undisclosed, fully undisclosed. In matters relating to maternity and infancy, and to authorize appropriations of federal funds for the purposes of the act, to appropriate our trusts and extort us and use our funds and all this stuff. Many examples may be given and were stated in the debates on the bill in Congress of regulations which may be imposed under the Act. So the forced registration of pregnancy governmental prenatal examination of expectant mothers, restrictions on the right of a woman to secure the services of a midwife or physician of her own selection, are measures to which the people of those states which accept its provisions may be subjected. And they put this conspicuously for a reason. So there is nothing which prohibits the payment of subsidies out of federal appropriations. Insurance of mothers may be made compulsory. The teaching of birth control, which is the killing of your children, and physical inspection of persons about to marry may be required. Like them sticking their hand in your vagina. So by Section 4 of the Act, the Children's Bureau is given all necessary powers to cooperate with the state agencies in the administration of the Act. Hence, it is given the power to assist in the enforcement of the plan submitted to it, and for that purpose by its agents to go into the several states and to do those acts for which the plans submitted may provide. As to what those plans shall provide, the final arbiters are the Bureau and the Board. Those in the middle, arbiter, intermediary, intercessor. So the fact that it was considered necessary in explicit terms to preserve from invasion by federal officials that the right of parent to the custody and care of his or her own child and the sanctity of his or her own home shows how far-reaching are the powers which were intended to be granted by the Act. So 1. The Act is invalid because it assumes powers not granted to Congress and usurps the local police power, peace officer power. So it's McCulloch vs. Maryland, 4 Wheat, 316-405. United States vs. Cruikshank, 92 United States, 542, 549-551. So in more recent cases, however, the court has shown that there are limits to the power of Congress to pass legislation purporting to be based on one of the powers expressly granted to Congress, which in fact usurps the reserved powers of the states. And that laws showing on their face detailed, par value, regulation of a matter wholly within the police power of the states, like a police state, will be held to be unconstitutional, although they purport to be passed in the exercise of some constitutional power. So they're using constitutional powers to discredit the Constitution and to create something different, like our ability to make contract and it can't be interfered with. These are loopholes. So Hammer vs. Dagenhart, 247, United States, 251, Child Labor Tax Case, 259, United States, 20, Hill vs. Wallace, 259, United States, 444. So the Act is not made valid by the circumstance that federal powers are to be exercised only with respect to those states which accept the Act. For Congress cannot assume and state legislators cannot yield the powers reserved to the states by the Constitution. Message of President Monroe, May 4th, 1822, Fort Elliott's Debates, page 525. Pollard's Lisi vs. Hagen, 3, Howe, 212. Escanaba Co. vs. Chicago, 107, United States, 678. Coyley vs. Oklahoma, 221, United States. These are all Supreme Court case rulings, so look them up. 559. Cincinnati vs. Louisville and Nashville, RR Co. 223, United States, 390. So there was Supreme Court case arguments and fights pertaining to this subject, and it'll be nice to actually go into those cases individually. So 2. The act is invalid because it imposes on each state an illegal option, either to yield a part of its powers reserved by the 10th Amendment or to give up its share of appropriations under the act to someone else. So a statute attempting by imposing conditions upon a general privilege to exact a waiver of a constitutional right is null and void. Harrison vs. St. Louis and San Francisco R.R. Co. 232, United States 318, Terrell vs. Berkey Construction Co. 257, United States 529. So 3. The act is invalid because it sets up a system of government by cooperation between the federal government and certain of the states. Not provided by the Constitution. So Congress cannot make laws for the states, and it cannot delegate to the states the power to make laws for the United States. In regarding RAR 140 U.S. 545, Knickerbocker Ice Co. vs. Stewart 253, United States 149, Opinion of the Justices 239, Mass 606. So the Maternity Act was eventually repealed, but parts of it have been found in other legislative acts, parts of it. So what this act attempted to do, so our actions helped it be repealed, dissolved, rejected, objected, disagreed upon. So what this act attempted to do was set up government by appointment, run by bureaucrats with redelegated authority to tax, to credit, which is in itself unconstitutional. What was once declared as unconstitutional by the Supreme Court of this nation in the past should be upheld in a court challenge today. The Constitution hasn't changed. What has changed is the way this government views human life. Amen. So the government now wants us as individuals to be tagged and tracked. That's why they're going to give people the chip, the mark of the beast, and put cameras everywhere to track the chips, to track you, to track your car, your phone, everything, GPS, everything, Wi-Fi, Bluetooth, polluted by low-wave frequency. So government mandated or legislated national ID, that's the chip, is unconstitutional any way you look at it. Federal jurisdiction to legislate for the several states does not exist and could never survive a court challenge as shown above. So writing letters to elected public servants won't save us when we all know their agenda does not include serving those who place them in power. Perhaps the 10th Amendment of the Federal Constitution, guaranteeing states' rights, will, if challenged, when making it known that we as individuals of the several states will not be treated as cattle of the United States Corporation. Government. If the federal government believes they own us, they really own the straw man though, not you, and as such have the right to demand national ID cards and health ID cards. Watch out. Which will in truth tag us as we tag our animals. Then let them bring forth the documents to prove their authority to legislate for it. If our Yah, given unalienable rights to life, liberty, and freedom, which were the foundation upon which this nation was created, although that's not true, do not exist, and liberty and freedom is only an illusion under which the American people suffer, then let the governments of this nation come forward and tell the people if we have no rights. But if we are indeed free, then we should not have to plead or beg before our elected public servants to be treated as such. If in truth we are not free, then perhaps it's time to let the final chapter of the great American Revolution be written. Hallelujah. So notice, information served herein is for educational purposes only. No liability assumed for use. The information you obtain in this presentation is not, nor is to be intended to be legal advice. Author does not consent to unlawful action. Author advocates and encourages one and all to adhere to, support, and defend all law which is particularly applicable. If anything in this presentation is found to be in error, a good faith effort will be made to correct it in timely fashion upon notification. Void where prohibited by law. I affirm. So now that we got that basic on the birth certificate, let's go ahead and proceed now. Let me see what we should go on to next. Hold on. Alright, let me see. Let's go to this real quick. Alright, so I'll be right back, my loves. Alright, we're going to continue on with where we left off. So, Title 46, Subtitle 3, Chapter 313, Subchapter 2, Section 3132.1. So this is dealing with filing, recording, and discharge. Filing, recording, and discharge. How current is this? So A1, a bill of sale, like a bill of exchange, conveyance, a bill of conveyance, a bill of mortgage, a bill of assignment, or related instrument, whatever bill, whenever made, that includes any part of a documented vessel that would be like your body or your birth certificate, a bill, a receipt, or a vessel for which an application for documentation is filed, or a vessel for which an application for documentation like birth, your body, your car, your house, must be filed with the Secretary of Transportation to be valid. To the extent the vessel is involved, against any person except A, the grantor, mortgager, or assigner, B, the heir or devisee of the grantor, mortgager, or assigner, that would be you, and C, a person having actual notice of the sale, conveyance, mortgage, assignment, or related instrument, notice. 2. Each bill of sale, conveyance, mortgage, assignment, or related... Hold on one second, my people. Hold on one... Alright, pardon me about that. Had to pause for 1 second. Being interrupted by fools with no respect. So each bill of sale, conveyance, mortgage, assignment, or related instrument that is filed in substantial compliance with this section is valid against any person from the time it is filed with the Secretary. Each bill of sale, conveyance, even your mortgage or assignment or related instrument that is filed like your lien in substantial compliance with this section is valid against any person from the time it is filed with the Secretary. So 3. The parties to an instrument or an application for documentation shall use diligence to ensure that the parts of the instrument or application for which they are responsible are in substantial compliance with the filing and documentation requirements. So these stuff must be filed and it must be documented. So 4. A bill of sale or a bill of exchange, a bill of conveyance, a proof of mortgage or bill of mortgage, a bill of assignment or proof of assignment or related instrument, like something being pledged or put up as collateral or something like that, may be filed electronically under regulations prescribed by the Secretary. B. To be filed, a bill of sale, conveyance, mortgage, assignment, or related instrument must 1. Identify the vessel. Identify the strawman. 2. State the name and address of each party to the instrument, like the informants, your mom and dad. 3. State if a mortgage, the amount of the direct or contingent obligations in one or more units of money, as agreed to by the parties, that is or may become secured by the mortgage through a pledge or collateral, excluding interest, expenses, and fees. 4. State the interest of the guarantor, mortgager, or assigner in the vessel. So as grantor, what is your interest or claim on this property or vessel? 5. State the interest sold, conveyed, mortgaged, or assigned. And 6. Be signed and acknowledged. So it must be signed and acknowledged, the main key ingredient. They save the best for last. Hallelujah. So C. If a bill of sale, conveyance, mortgage, assignment, or related document is filed that involves a vessel for which an application for documentation, like birth certificate or social, is filed, and the Secretary decides that the vessel cannot be documented by an applicant or an informant, 1. The Secretary shall send notice of the Secretary's decision, including reasons for the decision, to each interested party to the instrument filed for recording. And 2. 90 days after sending the notice as provided under Clause 1 of this subsection, the Secretary A. may terminate the filing, and B. may return the instrument filed without recording it under subsection, So, under subsection E of this section. D. A person may withdraw an application for documentation of a vessel. So you can withdraw an application for birth certificate and social, although you can't, for which a mortgage or security agreement, a lien, a levy, a charge has been filed under this section, only if the mortgagee consents. So E. The Secretary shall 1. Record the bills of sale, the bills of conveyances, the bills of mortgages, the bills of assignments, and related instruments of a documented vessel or real property, complying with subsection B of this section, in the order they are filed. So in the order they are filed. And 2. Maintain appropriate indexes or marks for use by the public of instruments filed or recorded or both. F. On full and final discharge of the indebtedness, on full and final discharge of indebtedness according to the laws that govern discharge of indebtedness, under a mortgage, under a birth certificate or security agreement, or a lien or levy, recorded under subsection E1 of this section. A mortgagee, which will be them, on request of the Secretary or mortgager, shall provide the Secretary with an acknowledged certificate of discharge, an acknowledged certificate of discharge of the indebtedness, in a form prescribed by the Secretary. So the Secretary shall record the certificate. So that the Secretary shall record the certificate. Either the certificate of indebtedness or final and full discharge of indebtedness. which is technically what the birth certificate is, or the security agreement that you're placing on your straw man. So G, the mortgage or related instrument, like a security agreement, of a vessel or real property or personal property covered by a preferred mortgage, a preferred security agreement, pledge, collateral, under section 31.322D of this title, that is later filed under this section at the time an application for documentation is filed, is valid under this section from the time the mortgage or instrument, like the discharging instrument, negotiable instrument, representing financing, become a preferred mortgage under section 31.322D. So H, on full and final discharge of the indebtedness under a mortgage deemed to be a preferred mortgage under section 31.322D of this title, a mortgagee, on request of the Secretary, a state, or mortgagor, shall provide the Secretary or the state as appropriate with an acknowledged certificate of discharge of the indebtedness in a form prescribed by the Secretary or the state as applicable. If filed with the Secretary shall enter that information in the vessel identification system, in the human identification system, under chapter 125 of this title. So you can use all this to not only discharge debt but also to record debt or some type of mortgage or pledge or collateral. These things must be recorded. In other words, there's recording, filing, and recording requirements. Record of lien. So that was in Title 46, I believe, United States Code. So let's continue on. So we're going to go on to the next document now. So this one is entitled 31 United States Code 3101. So Title 31 of the United States Code, Money and Finance. Subtitle 3, Financial Management, Fiscal Management. Chapter 31, Public Debt. And Subchapter 1, Borrowing Authority. So Section 3101, Public Debt Limit, or Public Credit Limit. So in this section, the current redemption value of an obligation, the current redemption value or OIDable value of an obligation or debt issued, like a presentment, a bill, on a discount basis, a original issued discount, and redeemable before maturity at the option of its holder, whoever accepts the presentment, is holding the presentment, is deemed to be the face amount. So the amount on the front is to be the face amount, the par value amount of the obligation. So B, the face amount of obligations issued under this chapter and the face amount of obligations whose principal and interest are guaranteed by the United States government, whose principal and interest P&I are guaranteed by the United States government, except guaranteed obligations held by the Secretary of the Treasury, because there are guaranteed obligations held by the Secretary of the Treasury, may not be more than 14,294,000. So it's pretty much 14,294 billion outstanding at one time. So you got to make sure all these things are up to date too, my people, because you know there might be a different type of limit, but it shouldn't pass 14,294 billion outstanding at one time. So as long as it's not this much outstanding at one time, you can withdraw and redeem whatever amount you want, subject to changes periodically made in that amount as provided by law through the congressional budget process described in Rule XLIX. To know how much you can withdraw and credit and all this stuff when you're monetizing debt. Of the rules of the House of Representatives, or as provided by Section 3101A or otherwise. So C. For purposes of this section, the face amount for any month of a debt, obligation, or presentment issued like a bond on a discount basis, OID, to be OID'd, 1099 OID'd, that is not redeemable before maturity at the option of the holder, like acceleration, of the obligation is an amount equal to the sum of 1. The original issue price of the obligation, plus 2. The portion of the discount or the interest income, personal income, on the obligation attributed to periods before the beginning of such month, as determined under the principles of Section 1272A of the Internal Revenue Code of 1986, which is entitled 26, without regard to any expectations contained in paragraph 2 of such section. So let's continue on. These are footnotes. See references in text note below. So these are revisions. These are other laws that have been put in and things like that. So if you want to dig deeper into that concept, you can, go into those public laws. So it changed over time, as you can see here, the amount. Hallelujah. So like it says right here, subsection C, Public Law 101-72, amended subsection C generally. Prior to amendment, subsection C read as follows: the face amount of beneficial interests and participations, except those held by their issuer, issued under Section 302C of the National Housing Act, which is entitled 12 United States Code 1717C, from July 1st, 1967 through June 30th, 1968, and outstanding at any time, shall be included in the amount taken into account in deciding whether the face amount requirement of subsection B of this section has been exceeded. This subsection does not require a change in the budgetary accounting for beneficial interests and participations. So I'm going to skip all that. So treatment of certain obligations of the United States. So Public Law 104-115, Section 1A through C, March 12, 1996, 110 Statute at Large, 825, authorized Secretary of the Treasury to issue, like bonds, to each federal fund obligations of United States under this chapter before March 30th, 1996, an amount not to exceed certain designated limits, exempted such obligations from public debt limit, and provided for termination of such exemption, and defined federal fund for purpose of section. So timely payment of March 1996 Social Security benefits guaranteed. So Public Law 104-103, Section 1, February 8, 1996, 110 Statute at Large, 55, as amended by Public Law 104-115, Section 1D, March 12, 1996, the next month, 110 Stat 8825, authorized Secretary of the Treasury to issue before March 1st, 1996, obligations of United States under this chapter in amount equal to monthly insurance benefits payable in March 1996 under Title II of the Social Security Act, which is in Title 42, United States Code 401 et sec, exempted such obligations from public debt limit and provided for termination of such exemption. So these are the limits to it, you know, limits to the obligations and debts and things like that. Like, you should not try to get anywhere near these numbers, because that's ridiculous that one person will pay that much. Whether you're using a black card or not, which I actually rebuke, stay away from it. I probably shouldn't have mentioned it, but I know a lot of people are being induced by the concept of that black card junk. Stay away from it. I have a very extremely bad feeling about it. So restoration of trust fund investments, which is your social account fund investments. Provisions requiring the Secretary of the Treasury to restore certain federal trust funds and government accounts to the position they would have been if the debt limitation of Title 31 United States Code 3101B had not prevented them from investing funds during specific periods were contained in the following acts. These right here, these three, I'm not going to go into them. So this right here was mainly on borrowing authority and public debt limit. Public debit limit. Look at debt as debit, because debt is money. That's the type of system we're in. So when we say debt, we're not actually talking about debt. We're actually talking about debit, credit. So let's go ahead and continue on with our lesson for today. So let's go into Title 31, Money and Finance, Subtitle 3, Financial Management, Chapter 31, Public Debt, Subchapter 2, Administrative. So, Section 3124, exemption from taxation, from being taxed, having to pay dues to man instead of the Most High. All due praise to Yah. Hallelujah. So, A, stocks and obligations of the United States government. So, obligations, debts, indebtedness, debit, credit, all that is stock of the United States government, are exempt from taxation by a state or political subdivision of a state. So obligations cannot be taxed, and we're exempt from taxation. So with stock, bonds, notes, all that, that's why you get a discount, or OID, from the funds that they're holding from you without a withholding consent agreement. So the exemption applies to each form of taxation, each form of credit that would require the obligation, the interest on the obligation, or both, to be considered in computing a tax, except 1. A non-discriminatory franchise tax or another non-property tax. Non-property tax, non-discriminatory franchise tax, instead of a franchise tax, impose on a corporation. So to be considered, so the exemption applies to each form of taxation that would require the obligation, the interest on the obligation, or both, to be considered in computing a tax, except a non-discriminatory franchise tax or another non-property tax instead of a franchise tax. Impose on a corporation, and 2. An estate or inheritance tax. So B. The tax status of interest on obligations, the credit status of interest, which is credit accrued in an account, an escrow account, on obligations, because there's usually an escrow account open for your obligations, so you can use the escrow account to discharge that obligation, and dividends. So the tax status of interest on obligations and dividends, earnings, or other income. So dividends, interest on obligations, and earnings are forms of income. From evidences of ownership, evidences of a lien, possession. Who is in possession of this thing? Who really controls it and own it? Issued by the government or an agency, and the tax treatment of gain and loss. Tax treatment, gain and loss, which you would do on the 1099 INT, I believe. From the disposition of those obligations. So I'm going to read it one more time. So the tax status of interest on obligations and dividends, earnings, or other income from evidences of ownership issued by the government or an agency, and the tax treatment of gain and loss from the disposition of those obligations and evidences of ownership is decided under the Internal Revenue Code of 1986, which is Title 26 United States Code, Section 1, et seq. An obligation that the Federal Housing Administration had agreed under a contract made before March 1st, 1941, to issue at a future date, has the tax exemption privileges provided by the authorizing law at the time of the contract. So this subsection does not apply to obligations and evidences of ownership issued by the District of Columbia. So this subsection, exemption of tax, does not apply to obligations and evidences of ownership issued by DC, which is like anything with a with a zip code and things like that denoting DC, a territory or possession of the United States, or a department, agency, instrumentality, or political subdivision of the district, territory, or possession. So that put place into the statute of limitation and or the statute at large and public law. So in subsection A, before clause 1, the words except as otherwise provided by law, all bonds, treasury notes, and other are omitted as surplus. See, I knew they were saying bonds and notes and stuff like that. I knew it. They speak in code. The words political subdivision of a state are substituted for municipal or local authority for clarity and consistency. The word applies is substituted for extends for clarity. So applying credit and extending credit is the same thing, or applying for credit. So the words directly or indirectly are omitted as surplus. In clause 1, the word instead is substituted for in lieu for clarity. So instead mean in lieu or in support. In subsection B, the word shares, certificates, stock or other, and sale or other are omitted as surplus. So shares, stock, certificates, all the same thing, like the birth certificate. The words the tax status of and the tax treatment of is decided under the IRC of 1954, Title 26, United States Code, Section 1, et seq. are substituted for shall not have any exemption as such, shall not have any special treatment as such, except as provided under the IRC of 1954 for clarity. The words on or after March 28, 1942 and 31, semicolon, 742 AA, first sentence words after semicolon related to the United States Maritime Commission, which is the War Commission, the United States War Commission, are omitted as executed. The last sentence is substituted for 31-742A, A, last sentence for clarity. The words any political subdivision thereof are omitted as include in agency or instrumentality. So municipal or local authority are another word to say agency or instrumentality of the Federal Reserve Corps. Alright, let's go on and move on to the next now. So now we're going to go into Public Law number 87-73D, Congress. HR, House Resolution 6976. Make sure you're taking notes, my friends. So to protect the currency system of the United States, the bond and promissory note system, DEP is money or credit system, to provide for the better use of the monetary gold stock of the United States and for other purposes, be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled, that the short title of this act shall be the Gold Reserve Act of 1934. Because this is, pertaining to the gold and all that stuff and what was occurring with that and why it's been replaced with, the currency system now in place. So this is called the Gold Reserve Act of 1934 and it's under HR House Resolution 6976, Public Law number 87-73D. So Section 2, A. Upon the approval of this act, all right, title, and interest in every claim of the Federal Reserve Board, of every Federal Reserve Bank, and of every Federal Reserve agent, like an escrow agent, a Federal Reserve escrow agent, in and to any and all gold coin and gold bullion, shall pass to and are hereby vested in the United States. And in payment thereof, of gold and silver, therefore credits in equivalent amounts in dollars. So that means we're able to redeem the notes in dollars. The gold with gold certificates and silver certificates. We're able to redeem it in gold. So in payment, therefore, credits in equivalent amounts in dollars are hereby established in the Treasury in the accounts authorized under the 16th paragraph of the section. So, in the 16th paragraph of Section 16 of the Federal Reserve Act, as heretofore and by this act amended, United States Code Title 12, Section 467. They might have changed it, so I'll look into that if I was you. So balances in such accounts shall be payable in gold certificates and gold certificate notes, which they took from us too, which shall be in such form and in such denominations as the Secretary of the Treasury may determine. All gold so transferred, not in the possession of the United States, shall be held in custody for the United States. So, and all gold so transferred, not in the possession of the United States, shall be held in custody for the United States and delivered upon the order of the Secretary of the Treasury. Like paid to the order of. And the Federal Reserve Board, the Federal Reserve Banks, and the Federal Reserve fiduciary agents shall give such instructions and shall take such action as may be necessary to assure that such gold shall be so held and delivered. Assure. So there is still gold and silver certificates out there. There's actually a stock market for that too. So B, Section 16 of the Federal Reserve Act, as amended, is further amended in the following respects in regard. 1. The third sentence of the first paragraph is amended to read as follows. They shall be redeemed in lawful money and lawful currency, silver and gold, on demand at the Treasury Department of the United States in the city of Washington, District of Columbia, D.C. They shall be redeemable in lawful money. The notes shall be redeemed in lawful money, or at any Federal Reserve Bank. 2. So much of the third sentence of the second paragraph as precedes the provision is amended to read as follows. The collateral security, like your body, your flesh, thus offered shall be notes, drafts, like bills, acceptance for values, bills of exchange, or acceptances, acceptance for value, acquired under the provisions of Section 13 of this Act, or bills of exchange endorsed by a member bank, which is a straw man, a citizen of the Feds, of any Federal Reserve District, and purchased under the provisions of Section 14 of this Act, or bankers' acceptances purchased under the provisions of said Section 14, or gold certificates. So 3. The first sentence of the third paragraph is amended to read as follows. Every Federal Reserve Bank shall maintain reserves in gold certificates. That used to be real currency because it was backed by something. Or lawful money, gold and silver, of not less than 35% against its deposits, and reserves in gold certificates of not less than 40% against the Federal Reserve notes in actual circulation. So provided, however, that when the Federal Reserve agent holds gold certificates as collateral for Federal Reserve notes issued to the bank, such gold certificates shall be counted as part of the reserve which such bank is required to maintain against its Federal Reserve notes in actual circulation. So the fifth and sixth sentences of the third paragraph are amended to read as follows. Notes presented for redemption, so gold certificates and silver certificates presented to be redeemed in gold and silver, or for credit, at the Treasury of the United States, shall be paid out of the redemption fund and returned to the Federal Reserve banks through which they were originally issued, and thereupon such Federal Reserve bank shall, upon demand of the Secretary of the Treasury, reimburse such redemption fund in lawful money. Or if such Federal Reserve notes have been redeemed by the Treasurer in gold certificates, then such funds shall be reimbursed to the extent deemed necessary by the Secretary of the Treasury in gold certificates, gold notes, and such Federal Reserve Bank shall, so long as any of its Federal Reserve notes remain outstanding, maintain with the Treasurer in gold certificates an amount sufficient in the judgment of the Secretary to provide for all redemptions to be made by the Treasurer. So Federal Reserve notes received by the Treasurer, otherwise than for redemption, may be exchanged for gold certificates. So Federal Reserve notes may be redeemed for gold certificates out of the redemption fund hereinafter provided and returned, like a OID, return to source, to the Reserve Bank or your account through which they were originally issued, through your account. the hard asset, treasury account, prepaid treasury direct account, or they may be returned to such bank for the credit of the United States. For credit. So 5. The 4th, 5th, and 6th paragraphs are amended to read as follows. The Federal Reserve Board shall require each Federal Reserve Bank, the 12 districts, to maintain on deposit in the Treasury of the United States a sum in gold certificates sufficient in the judgment of the Secretary of the Treasury for the redemption of the Federal Reserve notes issued to such bank or person, but in no event less than 5% of the total amount of notes issued, less the amount of gold certificates held by the Federal Reserve agent as collateral security. Top dollars for gold. What worth more? Paper or metal? So, but some deposit of gold certificates shall be counted and included as part of the 40% reserve herein before required. So I believe we can use this to actually get gold and silver, although this is I don't think it has an actual this was after HJR 192. This was in 1934, the Gold Reserve Act of 1934. So after HJR 192, they were still given gold certificates, but not actual gold and silver metal substance. It was illegal to have the substance, but not the certificates, because the certificates are considered currency, notes, just an instruction. So the board shall have the right, acting through the Federal Reserve agent, to grant in whole or in part, or to reject entirely the application of any Federal Reserve Bank for Federal Reserve notes. But to the extent that such application may be granted, the Federal Reserve Board shall, through its local Federal Reserve agent, supply Federal Reserve notes to the banks so applying, and such bank shall be charged with the amount of the notes issued to it, and shall pay such rate of interest as may be established by the Federal Reserve Board on only that amount of such notes, which equals the total amount of its outstanding Federal Reserve notes, less the amount of gold certificates held by the Federal Reserve agent. They can't put out more notes than they have in gold as collateral security. So Federal Reserve notes issued to any such bank shall, upon delivery, together with such notes of such Federal Reserve Bank as may be issued under Section 18 of this Act, upon security of the United States 2% government bonds. So there's 2% gold government bonds, or whatever that's supposed to be, become a first and paramount lien on all the assets of such bank or the people. So any Federal Reserve Bank may at any time reduce its liability for outstanding Federal Reserve notes by depositing with the Federal Reserve agent its Federal Reserve notes, gold certificates, or lawful money of the United States. So Federal Reserve notes so deposited shall not be reissued, rehypothecated, except upon compliance with the conditions of an original issue. So the Federal Reserve agent shall hold such gold certificates or lawful money available exclusively for exchange for the outstanding Federal Reserve notes when offered by the Reserve Bank of which he is a director. So upon the request of the Secretary of the Treasury, the Federal Reserve Board shall require the Federal Reserve agent to transmit to the Treasurer of the United States so much of the gold certificates held by him as collateral security for Federal Reserve notes, as may be required for the exclusive purpose of the redemption of such Federal Reserve notes. But such gold certificates, when deposited with the Treasurer, shall be counted and considered as if collateral security on deposit with Federal Reserve agent. So our gold was collateral security, that it was actually backing up the dollar, the note. Now we don't have that security no more because we have fiat. It's backed up by nothing. So they called our gold certificates collateral security. It's backed up by something. So 6. The 8th paragraph is amended to read as follows. All Federal Reserve notes and all gold certificates and lawful money issued to or deposited with any Federal Reserve agent under the provisions of the Federal Reserve Act shall hereafter be held for such agent under such rules and regulations as the Federal Reserve Board may prescribe, in the joint custody of himself and the Federal Reserve Bank to which he is accredited. Such agent and such Federal Reserve Bank shall be jointly liable for the safe keeping of such Federal Reserve notes, gold certificates, and lawful money, gold and silver, or currency. Actually, not gold and silver substance, because by this time it was abrogated, so it gave us notes. So nothing herein contained, however, shall be construed to prohibit a Federal Reserve agent from depositing gold certificates with the Federal Reserve Board, to be held by such board subject to his order. Subject to his order. So upon order, they shall obey. Nothing herein contained, however, shall prohibit a Federal Reserve agent from depositing gold certificates with the Federal Reserve Board, to be held by such board, or the Federal Window, or with the Treasurer of the United States for the purposes authorized by law. So the 16th paragraph is amended to read as follows. The Secretary of the Treasury is hereby authorized and directed to receive deposits of gold or of gold certificates with the Treasurer or any Assistant Treasurer of the United States when tendered by any Federal Reserve Bank or agent or Federal Reserve agent for credit to its or his account with the Federal Reserve Board, which is your Social Security account. So the Secretary shall prescribe by regulation the form of receipt to be issued, account receivable, to be issued by the Treasurer or Assistant Treasurer to the Federal Reserve Bank or Federal Reserve agent making the deposit, and a duplicate of such receipt shall be delivered to the Federal Reserve Board by the Treasurer at Washington, upon proper advices from any Assistant Treasurer that such deposit has been made. So deposits so made shall be held subject to the orders of the Federal Reserve Board. It shall be subject to the orders of the Federal Reserve Board, paid to the order of, and shall be payable in gold. Shall be payable in gold certificates or on the order of the Federal Reserve Board to any Federal Reserve Bank or Federal Reserve agent. You're pretty much a Federal Reserve agent, and your Federal Reserve Bank is where this funds is coming from, and the Federal Reserve Board is what give life to the 12 banks and you, the beneficiary. Well, really a straw man, pardon my language. I gotta make sure you understand the proper context of explaining this. So your straw man is the agent at the Treasury or at the Sub-Treasury of the United States, nearest the place of business of such Federal Reserve Bank or such Federal Reserve agent, So the order used by the Federal Reserve Board in making such payments shall be signed by the governor or vice governor or such other officers or members as the board may by regulation prescribe. So the form of such order shall be approved by the Secretary of the Treasury. So the 18th paragraph is amended to read as follows. So I believe the Federal Reserve Act been amended by this thing. Deposits made under this section standing to the credit of any Federal Reserve Bank with the Federal Reserve Board shall at the option of said bank be counted as part of the lawful reserve which it is required to maintain against outstanding Federal Reserve promissory notes, IOUs. So it must be equal dollars as there is in gold. There should not be more dollars in circulation than gold. But they had to cause that so they can stretch their limits to take away their gold. Or as a part of the reserve it is required to maintain against deposits. So there is a reserve that is required to be maintained. They call it a 10% deposit. And the rest is excess funds according to the Modern Money Mechanics book. So section 3. The Secretary of the Treasury shall by regulations issued hereunder with the approval of the President prescribe the conditions under which gold may be acquired and held, transported, melted or treated, imported or exported, or earmarked. A. For industrial, professional, and artistic use. B. By the Federal Reserve Banks for the purpose of settling international balances. And C. For such other purposes as in his judgment are not inconsistent with the purposes of this act. So gold in any form may be acquired, transported, melted, or treated, imported, exported, or earmarked, or held in custody for foreign or domestic account, except on behalf of the United States, only to the extent permitted by and subject to the conditions prescribed in or pursuant to such regulations. Such regulations may exempt from the provisions of this section, in whole or in part, gold situated in the Philippine Islands or other places beyond the limits of the continental United States, the continent of the United States Corps. So section 4. Any gold withheld, acquired, transported, melted, or treated, imported, exported, or earmarked, or held in custody in violation of this act or of any regulations issued here under, or licenses issued pursuant thereto, shall be forfeited to the United States. It shall be forfeited to us, and may be to our straw man, and may be seized and condemned by like proceedings as those provided by law for the forfeiture, seizure, and condemnation of property imported into the United States contrary to law. And in addition, any person failing to comply with the provisions of this act or of any such regulations or licenses, permission, shall be subject to a penalty, a sanction equal to twice the value of the gold in respect of which such failure occurred. So section 5. No gold shall hereafter be coined, and no gold coin shall hereafter be paid out or delivered by the United States. And that's why you have only silver coins and browns and everything else but gold. Provided, however, that coinage may continue to be executed by the mints of the United States for foreign countries in accordance with the Act of January 29th, 1874, which is in the United States Code Title 31, Section 367. There goes Title 31 again. So all gold coin of the United States shall be withdrawn from circulation, and together with all other gold owned by the United States shall be formed into bars of such weight and degrees of fineness as the Secretary of the Treasury may direct, which is .99 gold, and their bricks, bars. So Section 6. Except to the extent permitted in regulations which may be issued hereunder by the Secretary of the Treasury, with the approval of the President, no currency of the United States shall be redeemed in gold. Provided, however, that gold certificates owned by the Federal Reserve banks shall be redeemed at such times and in such amounts as in the judgment of the Secretary of the Treasury. So you can redeem gold certificates in promissory notes, dollars. The same value though, are necessary to maintain the equal purchasing power of every kind of currency of the United States. So it's necessary to maintain the equal purchasing power of every kind of currency of the United States. And provided further that the reserve for United States notes and for Treasury notes of 1890 and the security for gold certificates, including the gold certificates held in the Treasury for credits payable therein. So they got accounts payable which we are able to receive. To be able to receive, they have to pay, we receive. Account payable, account receivable. Shall be maintained in gold bullion equal to the dollar amounts required by law. And the reserve for Federal Reserve notes shall be maintained in gold certificates or in credits payable in gold certificates maintained with the Treasurer of the United States under Section 16 of the Federal Reserve Act, as heretofore and by this act amended. So no redemptions in gold shall be made except in gold bullion. So we can pass around gold bullions and things like that, bearing the stamp of the United States Mint or assay office in an amount equivalent at the time of redemption to the currency surrendered for such purpose. Hold on one sec, I'm gonna grab some water, hold on. So let's continue on. Hallelujah. Section 7. In the event that the weight of the gold dollar shall at any time be reduced, the resulting increase in value of the gold held by the United States, including the gold held as security for gold certificates and as a reserve for any United States notes and for Treasury notes of 1980, shall be covered into the Treasury as a miscellaneous receipt, accounts receivable, which they have to pay. And in the event that the weight of the gold dollar shall at any time be increased, the resulting decrease in value, inflation, deflation, of the gold held as a reserve for any United States notes, and for Treasury notes of 1890, and as security for gold certificates, shall be compensated by transfers of gold bullion from the general fund, the mutual fund, and there is hereby appropriated an amount sufficient to provide for such transfers and to cover the decrease in value of the gold in the general fund, the mutual fund. Section 8. Section 3700 of the revised statutes, which is in the United States Code, Title 31, Section 734, is amended to read as follows. Section 3700. With the approval of the President, the Secretary of the Treasury may purchase gold in any amount at home or abroad with any direct obligations, coin, or currency of the United States, authorized by law, or with any funds in the Treasury not otherwise appropriated at such rates, interest rates, and upon such terms and conditions as he may deem most advantageous to the public interest. Any provision of law relating to the maintenance of parity or limiting the purposes for which any of such obligations, coin, or currency may be issued, or requiring any such obligations to be offered as a popular loan or on a competitive basis, or to be offered or issued at not less than par, to the contrary notwithstanding. So all gold so purchased shall be included as an asset of the general fund of the Treasury. To actually purchase these gold certificates from you. Section 9, Section 3699 of the revised statutes, which is in Title 31 USC Section 733, is amended to read as follows. So Section 3699. The Secretary of the Treasury may anticipate the payment of interest on the public debt by a period not exceeding 1 year from time to time, either with or without a rebate of interest upon the coupons, remittance, voucher, ticket, as to him may seem expedient. And he may sell gold in any amount at home or abroad in such manner and at such rates and upon such terms and conditions as he may deem most advantageous to the public trust. And the proceeds of any gold so sold shall be covered into the general fund of the Treasury, provided, however, that the Secretary of the Treasury may sell the gold which is required to be maintained as a reserve or as security for currency issued by the United States or the United States citizens, only to the extent necessary to maintain such currency at a parity with the gold dollar. So Section 10A, for the purpose of stabilizing the exchange value of the dollar. Stabilizing the exchange value of the dollar. The Secretary of the Treasury, with the approval of the President, directly or through such agencies as he may designate, is authorized for the account of the fund established in this section to deal in gold and foreign exchange and such other instruments of credit and securities as he may deem necessary to carry out the purpose of this section. So such agencies as he may designate is authorized for the account of the fund established in this section to deal in gold and foreign exchange. SEC, U.S. SEC, the United States Securities Exchange Commission, and the trade, the Federal Trade Commission, FTC. Such other instruments of credit and securities as he may deem necessary to carry out the purpose of this section. So this section creates the account of the funds, or account for the bullions and the gold certificates and the like. So accounts were being created during that time. That's how we got to this point, and why we have the whole concept of accounts and stuff. Accountability. Someone got to be accounted for. So an annual audit of such fund, an annual investigation of the financial accounts, the ledger books, the balance sheets, shall be made, and a report thereof submitted to the President of the Corps. So B, to enable the Secretary of the Treasury to carry out the provisions of this section, there is hereby appropriated out of the receipts which are directed to be covered into the Treasury, so receipts are redeemable, under sections 7 hereof, the sum of $2 billion, which sum, when available, shall be deposited with the Treasurer of the United States in a stabilization fund hereafter called the fund, under the exclusive control of the Secretary of the Treasury, the fiduciary or trustee of our accounts and funds, with the approval of the President Trustee, whose decisions shall be final and not be subject to review by any other officer of the United States. Are you an officer of the United States Corps? No. The fund shall be available for expenditure, to be expended, corporate expenditure, under the direction of the Secretary of the Treasury, and in his discernment, for any purpose in connection with carrying out the provisions of this section, including the investment and reinvestment in the direct obligations of the United States, of any portions of the fund which the Secretary of the Treasury, with the approval of the President, from time to time determine are not currently required for stabilizing the exchange value of the dollar. It used to be exchangeable, now it's not. So this been taken away too, because we don't have gold certificates no more. So we must ask, when did that happen? Why did it happen? And what is in place of that, other than just these fiat dollars backed up by nothing, which will eventually become the age of chips, credit cards, and wire transfer. So the proceeds of all sales and investments and all earnings and interest accruing under the operations of this section shall be paid into the fund, the stabilization fund, and shall be available for the purposes of the fund. So all the powers conferred by this section shall expire 2 years after the date of enactment of this act. Okay. Unless the President shall sooner declare the existing emergency ended and the operation of the stabilization fund terminated. So we're still under a state of emergency. And that's why this had expired 2 years later after the date of the enactment of this the Gold Reserve Act, Gold Note Act. But the President may extend such period or apply such period for not more than 1 additional year after such date, by proclamation recognizing the continuance of such national bankruptcy emergency. So we've been in the fall for quite a while. The stock market been falling. So section 11, the Secretary of the Treasury is hereby authorized to issue, with the approval of the President, such rules and regulations as the Secretary may deem necessary, or proper to carry out the purposes of this act, which you can find on the Federal Reserve Board website. So Section 12, Paragraph B, 2 of Section 43, Title 3 of the Act approved May 12, 1933, Public Numbered 10, 73rd Congress, that's HJR 192, is amended by adding 2 new sentences at the end thereof, reading as follows. Nor shall the weight of the gold dollar be fixed in any event at more than 60 percentum of its present weight. The powers of the President specified in this paragraph shall be deemed to be separate, distinct, and continuing war powers, and may be exercised by him, exercising martial law, war law, from time to time, severely or together, whenever and as the express objects of this section in his judgment may require. Reasonable judgment, but they don't care about that. President's president to them. Shouldn't have voted for him if you didn't want him to have this type of force. So except that such powers shall expire 2 years after the date of enactment of the Gold Reserve Act of 1934, unless the President shall sooner declare the existing emergency ended. But the President may extend such period for not more than 1 additional year after such date by proclamation recognizing the continuation of such emergency. So I'm not sure if he proclaimed that we're continuing a state of emergency or if it has ended. And that's something to research and look into, because I'm not going to make a video about that probably unless I'm going to go into the warning of martial law coming, which is already here and been here, and they're going to pretty much just reinforce it. I heard they reinforce it each year actually. That's what I heard, is hearsay. So do your research. Maybe the emergency ended, or maybe it didn't. But are we still in a credit-based system or actually gold and silver-based system? That will let you know if we're still in a state of credit. So, paragraph 2 of subsection B of section 43 of Title 3 of an act entitled An Act to Relieve the Existing National Economic Emergency by increasing agricultural purchasing power to raise revenue for extraordinary expenses, agriculture like land slaves, incurred by reason of such emergency, to provide emergency relief with respect to agricultural indebtedness, to provide for the ordinarily liquidation of joint stock land banks, and for other purposes, approved May 12, 1933, is amended by adding at the end of said paragraph 2 the following. So the President, in addition to the authority to provide for the unlimited coinage of silver at the ratio so fixed, under such terms and conditions as he may prescribe, is further authorized to cause to be issued and delivered to the tenderer of silver for coinage. So silver certificates in lieu or instead of the standard silver dollars to which the tenderer would be entitled, and in an amount in dollars equal to the number of coined standard silver dollars that the tenderer of such silver for coinage would receive in standard silver dollars. She should receive the equal value of silver in dollars, just like with gold. So this has been amended right here, this section. So the President is further authorized to issue silver certificates in such denominations as he may prescribe, in any form that he choose, against any silver bullion, silver or standard silver dollars in the Treasury not then held for redemption of any outstanding silver certificates, and to coin standard silver dollars or subsidiary currency for the redemption of such silver certificates, to redeem the silver certificates. So everything used to be redeemable, recoupable, because there's something backing up this money, and that would be the last form of payment, is actually recouping it, receiving it, retrieving it, redeeming it. So the president is authorized in his discretion to prescribe different terms and conditions, and to make different charges, or to collect different seigniorage for the coinage of silver of foreign production than for the coinage of silver produced in the United States or its dependencies, the people that depend upon them. The silver certificates herein referred to shall be issued, delivered, and circulated substantially in conformity with the law now governing existing silver certificates, except as may herein be expressly provided to the contrary, and shall have and possess all the privileges and the legal tender characteristics of existing silver certificates now in the Treasury of the United States or in circulation. So President have the power to change all this and control all this and do what he wants, pretty much, which I'm pretty sure they have. And these if you do research and look up the pictures of the currency of America and the money of America and the gold bullions and all that, and you see the pictures, it should give you a great understanding of how far we came. So the president is authorized, in addition to other powers, to reduce the weight of the standard silver dollar in the same percentage that he reduces the weight of the gold dollar. The president is further authorized to reduce and fix the weight of subsidiary coins so as to maintain the parity of such coins with the standard silver dollar and with the gold dollar. Section 13. All actions, regulations, rules, orders, and proclamations heretofore taken, promulgated, made, or issued by the President of the United States or the Secretary of the Treasury under the Act of March 9, 1933, or under Section 43 or Section 45 of Title III of the Act of May 12, 1933, are hereby approved, ratified, and confirmed. Section 14A. The Second Liberty Bond Act, as amended, is further amended as follows. So 1. By adding at the end of Section 1, United States Code, Title 31, Section 732, Supplemental Rule, 7, Title 31, Section 752. I would look that up if I was you, because a lot of things changed. A new paragraph as follows. Notwithstanding the provisions of the foregoing paragraph, notwithstanding the provisions, which means stand it, the Secretary of the Treasury may from time to time, when he deems it to be in the public interest, offer such bonds otherwise than as a popular loan. So they can loan these things out. And he may make allotments in full or reject or reduce allotments upon any applications whether or not the offering was made as a popular loan. A loan. That's where these banks get that concept from. You see how everything promulgated, how it was created, what it constitutes. So there's a lot more going on than you know and believe and feel and see. There's a lot more to things. There's a lot more to me. There's a lot more to your president. There's a lot more to him and her and them. Yeah, giggle all you want. So too, by inserting in Section 8, United States Code, Title 31, Section 771, after the word certificates of indebtedness, a comma and the words Treasury bills. 3. By striking out the figures 7,500 billion where they appear in Section Title 18 United States Code, Title 31, Section 753, and inserting in lieu thereof the figures $10 billion. So 4. By adding thereto 2 new sections as follows. Section 19. Notwithstanding any other provisions of law, premeditated thoughts of bylaw, corporate law, administrative law, any obligations authorized by this act may be issued for the purchase, redemption, or refunding at or before maturity of any outstanding bonds, notes, certificates of indebtedness, or treasury bills, which are the notes, the dollars. Actually, every bill they pass, congressional bill, has a charge of the United States, or to obtain funds for such purchase, redemption, or refunding under such rules and regulations, terms, and conditions as the Secretary of the Treasury may prescribe. I believe the system still works similar. You just got to get up to date and keep up to date with it. So Section 20. The Secretary of the Treasury may issue any obligations authorized by this Act and maturing not more than 1 year from the date of their issue on a discount basis and payable at maturity without interest. That's OID. Any such obligations may also be offered for sale on a competitive basis. So any such bonds or obligations may also be offered for sale in the security market on a competitive basis under such regulations. I mean, investors bid on it, and upon such terms and conditions as the Secretary of Treasury, ST, may prescribe. And the decisions of the Secretary in respect of any issue shall be final. So Section 6 of the Victory Liberty Loan Act, which is in United States Code Title 31, Section 767. Supplemental Law Number 7, Title 31, Section 767 to 767A, is amended by striking out the words "for refunding purposes," together with the preceding comma at the end of the first sentence of subsection A. So C. The Secretary of the Treasury is authorized to issue gold certificates in such form and in such denominations as he may determine against any gold held by the Treasurer of the United States, except the gold fund held as a reserve for the United States notes and Treasury notes of 1890. So the amount of gold certificates issued and outstanding, which is in circulation, shall at no time exceed the value at the legal standard of the gold so held against gold certificates. Section 15. As used in this Act, the term United States means the government of the United States. The term the continental United States means the states of the United States, the District of Columbia, and the territory of Alaska. The term currency of the United States means currency which is legal tender in the United States and include United States notes, Treasury notes of 1890, gold certificates, silver certificates, Federal Reserve notes, and circulating notes of Federal Reserve banks and national banking associations. And the term person means any individual, partnership, association, or corporation. Told you person mean corporation. including the Federal Reserve Board, the Federal Reserve banks, and Federal Reserve agents. So persons are Federal Reserve agents. Banks, corporations, associations. Wherever reference is made in this act to equivalents as between dollars or currency of the United States and gold, $1 or $1 face amount of any currency of the United States equals such a number of grains of gold, 9/10 fine, as at the time referred to are contained in the standard unit of value. That is, so long as the president, like units of value, is like units of account, like Euro or USD or whatever else they got out there. That is like Amero. So that is, so long as the president shall not have altered by proclamation the weight of the gold dollar under the authority of Section 43, Title 3 of the Act approved May 12, 1933, as heretofore and by this Act amended. 25 8/10 grains of gold, 9/10 fine, and thereafter such a number of grains of gold, 9/10 fine, as the president shall have fixed under such authority. War power. So Section 16. The right to alter, amend, or repeal this act is hereby expressly reserved. If any provision of this act or the application thereof to any person or circumstances is held invalid, the remainder of the act and the application of such provision to other persons or circumstances shall not be affected thereby. Section 17. All acts and parts of acts inconsistent with any of the provisions of this act are hereby repealed. Approved January 30th, 1934. So before we finish off for today, I did want to show you guys this real quick. Remember, you can contact me at godlivesinourheart@hotmail.com. So let me go ahead and look up gold bullion. I've seen this before, but I'm going to show it on and for the record, especially for the viewers that have not seen this. I am very considerate. Now, I'm not sure what they looked like back then, but we'll get a little glimpse into the past and see what we used to actually deal with. There goes the bricks, the bars. There goes the gold, the silver plates, and they've been printed on them. They've been printed. They're fine gold, refined, melted and all by goldsmiths like the old days. Yes, they do exist still, the goldsmiths. So nothing really changed all the way. Check this out right here. They got a whole collection. Hallelujah. Look at all that gold right here. Wow. 1,000 gram of pure gold. 999.9. They even have serial numbers too, so you can track them down and all. I guess I can't really click on that. It's all good. So these are what they call gold bullions. Gold bullions. Gold coins and gold bullions. So that's 1 ounce fine gold. That's almost less of 1 ounce, almost 0.999 gold. Alright, and we used to weigh things out too and all. So let's go up. I'm pretty sure silver bullions look the same. Just want to look this up real quick. Alright, these are gold, silver coins and silver bullions. I think some of them actually platinum. Wow, this is beautiful. Alright, this is looking very good. With 10 troy ounce 0.999 fine silver. 1 ounce fine silver. So these are all bullions right here. Take a very good glimpse of what we used to be dealing with. Things have changed a lot. And they had all type of forms of them too. All types of prints and everything. Statue of Liberty, man. They got bullets. Yeah, when they do say bullion, I do think of bullets. Matter of fact, did you know the Statue of Liberty is a man? Y'all should look that up. He's actually a man in one of them ancient Roman judge robes. You know, they used to wear things like robes. And it's actually not a man. What's on top of the head is supposed to be a crown of thorn type of thing. A crown, or the sun. Worship of the sun. So before we continue, let's look up silver certificate. This is going to be very good for my viewers so they can be able to have a insight on what things used to look like before it reached this point. Because you cannot understand where you're at now if you don't understand where you used to be. So like this right here says $1 silver. There goes a serial number. It probably matched with the serial number on the silver too. There was like correlation. So people didn't get what was not theirs. And I'm pretty sure they started to write promissory notes on paper before they started to make a fixed one. Because look, it says silver certificate at the top too. You know, everything looked the same, but it says silver certificate at the top. Now it says the Federal Reserve Bank at the top, or Federal Reserve Note. So we don't have certificates no more. We have nothing but notes now. They progressed us into this very smoothly and easily. So these are all fractional reserves. Is backed up by something. Silver certificates and stuff like that. See, this one even looked like gold a little bit on it. $10. We went from we went from silver certificates to dollars. $10. Cool. So last one, on it for the record, just for my viewers. So we dealt with bullions, and we've also dealt with certificates. They're like certificates of deposit. There goes $100 gold coin, or in gold. $10 gold coin. They call it $10 gold coin right there. Let's continue on. $10. You see, there's gold here. You know, to let you know it was, you know, collateral security is backed up by something. And yeah, these are certificates. They're all money. Yeah, even your college certificates and stuff, they're all money. High school certificates and all, they're actually all money. Alright, let's continue on. So gold, $100 gold, $10 in gold coin, coupons, you know, tickets, vouchers, all that was money. And they still are. I don't believe they're going to take away some of these rights. They're just going to keep certain people dumb and ignorant, that's all. So they won't be able to redeem jack. Wow. Well, I truly hope you guys enjoyed this video today. I hope you have found this fascinating. When we come back for part number 3, we're going to actually be going into, let me see. Alright, we did all that. We're going to be going into the exemption. This is going to be very, very important. So after we go into the exemption, I got a couple of other things I want to read to you guys. So there's going to be a couple of parts to this video, over 5. I don't expect for you to keep up with me, but I do hope that you do, so that you can get a thorough understanding of my presentation here. So you know, I know I didn't do this in vain. By the way, if you would like to donate or give anything to me, I do have a Western Union account. I will be setting a PayPal account soon, so you can be able to, you know, donate or give if you want to. It does help out a lot. You don't have to, I don't mind. Eventually I'm going to start making my own funds, you know, through All I Know. But it's only through your support and through your you know, through your effort and good faith that I'm able to actually do such thing. Let's stop funding the evil and wicked people who don't deserve our funds. Let's start bringing the money back to our people. You know what I'm saying? We've been crediting the wrong people for so long. Let's bring the money back to those who deserve it. If you believe I deserve it, contact me at God Lives in Our Heart. If you don't believe I deserve it, just pretend you never heard what I said. Shalom, everyone. God bless. Yahuwah Barakatah.